Good morning. Mr. Griffin?
Yes, thank you, Your Honor. Before we bring the jury in, I would like to put on the record the basis of my objection to the redirect of Agent Owens regarding the roadside shooting. Understanding the court's ruling was that I opened the door to that based on my cross-examination. This is the first case I've had the benefit of being able to go back to YouTube and see exactly what was asked on direct and what was asked on cross. I have typed it out. Your Honor, it's very brief. On direct examination, Mr. Metters asked Agent Owens, question, at some point in 2021 in the fall, did a financial investigation begin in Alec Murdaugh? His answer was yes, sir. Question, would it be fair to say that the investigations overlap with each other? Answer, it did. Question, would it be fair to say that the two investigations fed off each other? The answer is yes, they did. From the information I was learning from the financial investigation, it gave me additional people to consider and to look at Mr. Murdaugh as a reason why or why not. The next question, were the individuals in the finance investigation that you also interviewed in this investigation? He said, yes, I did. And then the question, did you learn information from the grand jury testimony? He says, yes, I did. Then the question, did you follow up on that information? He said, yes, I did. That was elicited on direct examination. My cross-examination, I began on this topic. You also testified in the fall of 2021 there started up a financial investigation. Yes. You said it fed off and overlapped with the murder investigation. Yes. You developed information that Alec was stealing money to support a drug addiction. Yes, that was reported. Question, you learned that Alex was paying up to $50,000 a week to buy drugs. Yes, that is what was reported. You learned that Alex was buying from Curtis Eddie Smith. Yes. You learned that Eddie was buying from the Sand Hill drug gang. Yes. You learned that Eddie owed the Sand Hill drug gang a lot of money. Yes, but they were not worried about getting their money because it was Murdaugh. Question, did you ever conduct a cell phone analysis of the Sand Hill drug dealer's cell phones to see if they were at Moselle on June the 8th? Answer, no, because in my experience they use burner phones. Question, you never got DNA from them to cross-check against the unknown DNA on Maggie's fingernails. Answer, no. Question, you never put them in the investigative circle, did you? Answer, my understanding is that investigation is continuing and is being conducted by the DEA. And from that, Your Honor, there were no questions related to the roadside shooting, no questions related to whether Alec lied to the police in connection with the roadside shooting. It was all about him stealing money from clients to support his drug addiction, which is evidence that was already in the case. Your Honor, I sent the court via email earlier today the case of State v. Hayward, 426 SC 630, which is a 2019 case where the Supreme Court reversed Judge Young on an opening the door theory.
The same Supreme Court reversed the Court of Appeals.
Excuse me, the Supreme Court reversed the Court of... Sure.
Yes.
The defendant was convicted. It went... The Supreme Court, the Court of Appeals affirmed, and the Supreme Court reversed the Court of Appeals. That's right. Yes. And vacated the conviction based upon the introduction of propensity evidence, 404 evidence on the theory of opening the door. And in that opinion, Justice Hearn is very specific to state that the courts have to be very careful and very wary of thinly veiled attempts to show propensity by way of the open door doctrine, and that the testimony in response must be proportional and confined to the topics to which counsel had opened the door. And again, I go back, we did not open the door to any roadside shooting, any insurance fraud, anything with regard to Alec lying to the police. And so that was the basis. I just objected, so I want to put that in the record. Today, they intend to present a full panoply of evidence on the roadside shooting. And, Your Honor, we would oppose that.
What do you mean a full panoply?
Well, they've asked to, that they're going to, my understanding is they're putting up Agent Kelly to talk about his investigation of the roadside shooting. We got a request this morning for them to play the hospital videotape of Alec in the Savannah Hospital, which is over an hour, where he's being interviewed by SLED agents, and he's meeting with a sketch artist to draw up a sketch of the roadside shooter, and that they plan to introduce that evidence. They plan to introduce, as we understand it, follow-up evidence of when Alec gets to detox in Atlanta, when he calls back with Mr. Harpootlian and I, and gives a full statement about the roadside shooting and about how he had lied to them previously, how he was sorry.
Is that the same video or
They're two separate. I mean, second is just an audio tape. But Your Honor, I just go back to State v. Hayward, where the court says testimony in response must be proportional and confined to the topics which counsel has opened the door. And so they intend to spend 3 hours of testimony here today, and it's not proportional, and it's not related to the topic for which the court, I believe, should find that. I don't think I opened any door, because I think the evidence was already in the case.
All right.
And it was in response to direct. It wasn't something I brought up.
May it please the Court, Your Honor. To go back, obviously we had this issue and we addressed it yesterday morning.
This time we're dealing with the issue of the court's, the exception or statement for the record that Mr. Griffin wanted to make concerning the court's ruling yesterday. We're not dealing with any anticipated testimony today at this time. I'm not ruling based on what, well, I've already ruled, but I'm entertaining these comments for the record regarding yesterday's ruling. So go ahead.
I think, Your Honor, if you listen, obviously, to the excerpts that Mr. Griffin just read, and you put that in the context of everything that had developed, starting with Marion Proctor, that the door is more than opened, and the State's intent in that regard is to fully respond to and flesh out the very examination.
The State's intent in that regard, we're talking about yesterday's ruling, so we can close the door on that. Do you have anything else to say about the court's ruling yesterday?
No, other than the examination, the redirect examination clearly was in response to and appropriate opening the door after that examination, and that's I think that Your Honor's ruling was appropriate in that regard, and I think that again that has opened the door to exploration of those issues.
Concerning the court's ruling yesterday, and also State v. Hayward, Mr. Owens, in questioning Mr. Griffin and cross-examining investigator Owen, got into this circle of interest that Alex is in the circle, then cross-examined the witness regarding, did you consider Eddie Smith to be in the circle? Well, did you consider some unknown gang members, whoever they might be, to be in this circle? Did you know that Alex was spending $50,000 per week supporting a drug habit, presumably through Eddie Smith, and that he owed money or he was indebted? So Mr. Griffin introduced the relationship between the defendant and Eddie Smith. The court conducted a pretrial, a hearing outside the presence of the jury, addressed the issue, made it clear that the roadside shooting was a bridge too far. Then the defense decided to build a road over that bridge, decided to just go right there as if they could dance through fire without getting burned, scarred, or anything. The door was open. This is not the same as the situation in State v. Hayward, where a co-defendant, a cooperating co-defendant, is being questioned about unrelated matters, totally unrelated to the case, and the Supreme Court felt Judge presiding judge went too far in allowing evidence not proportional to what was open and which he already ruled should not be introduced. I find that what this court allowed on yesterday was proportional because it was in relation to evidence elicited not by the state but by the defendant, and the state is entitled to explore this relationship between the defendant and Eddie Smith. And then we'll have further discussions at some point regarding this limitation of just randomly throwing out names of people, or suspicions and speculations regarding on the issue of third-party guilt. But to the extent that the defense sought to introduce the relationship between the defendant and Eddie Smith, and then to seek to infer that Eddie Smith might have been or should be a suspect in the murder, then to prohibit the state from saying, well, if Eddie Smith should be a suspect, and Mr. Murdaugh, who at the outset engaged in his form of problem solving by telling the state what this case was all about and the murder was all about, meaning the boat crash, then later engaging what appears to be a conspiracy along with the person that the defense seeks to insinuate to be or should have been a suspect. The state is entitled to explore that. The extent to which the state should be entitled to explore that, that's open for discussion today, but not based on the court's ruling yesterday. The court in the Hayward case did indicate that the court should be careful as the nature and extent to which these other matters should be allowed to go into, and I intend to do that. But the record is protected to the extent that Mr. Griffin went through YouTube and citing what his version of what he said yesterday, excluding the portion that's more relevant and important to the court's ruling. But the record speaks for itself on all of that, and the court's ruling stands as it was given on yesterday.